It's Wednesday, the 6th of July, 2022. Good afternoon, Namibia, and a very warm welcome to today's discussion here at the Government Information Center, coming to you live from Windhoek. I'm your host, Helene Philip Stamunyela, and I'll be keeping you company for the next 50 minutes or so. Today, we are discussing the basic conditions of employment in Namibia. The session today aims to create awareness on basic conditions of employment, as well as serve as a reminder between employers and employees to ensure that these set conditions of employment are in place at all times. And finally, to highlight the processes and procedures that need to be employed in order for the set conditions of employment to take place. But before we can continue with today's discussion, I'd like to accord this opportunity to Dr. Kalumbi Shangula to give us our daily dose of the COVID-19 health update. Doctor, good afternoon.
Good afternoon, moderator. Good afternoon, esteemed panelists. Good afternoon, fellow Namibians. I'm pleased to present the COVID-19 report for the 5th of July, 2022. We have received 268 results in the last 24 hours reporting cycle. And out of those, 15 of them have tested positive for COVID-19, representing 5.6% positivity ratio. Of these cases, 14 are new cases and 1 is a reinfection, consisting of there are 9 females and 8 males, and 6 males. The age range from 22 years old to 72. They as follow. Erongo, 3, with Swakopmund having 2, and Walvis Bay, 1. Kavango East, 3 from Rundu. Zambezi, 3 from Katimamulilo. Comas, 2 from Windhoek. Wangwena, 2 from Ngela, and 1 from Karasberg, registered in Loderet. Among the confirmed cases, there are 5 healthcare workers. 5 cases are fully vaccinated, of which 4 have also received a booster dose, and 10 cases are not vaccinated. 30 cases from 4 regions have recovered as follow. Comas 23, Oshkoto 5, Umsati and Kunene 1 each. The number of active cases now stand at 351. 29 cases are currently hospitalized, of which 4 are in intensive care unit. One of the admitted cases has received 1 dose of COVID-19 vaccine. 1 is fully vaccinated, and none of those in ICU is vaccinated. The hospitalization are as follow. Erongo 6, Oshana 5, Comas and Ohangwena 4 each, Zambezi 3, Umsati and Oshkoto 2 each, Karas, Kunene and Ochodambujupa 1 each. We are reporting 1 COVID-19 related death, that of a 17-year-old female from Opua who died in a health facility on the 22nd of June 2022. The deceased was not vaccinated. By the 4th of July, a total of 475,973 people aged 18 years and above have received 1 dose of COVID-19 vaccine, representing 32.3% of the adult target population. A total of 151,849 have received the Johnson & Johnson vaccine, while 265,791 adults have received 2 doses of the other vaccine types. Hence, 417,640 adults have completed their vaccination schedule, translating into 28.4% of the target population. 24,247 children aged 12 to 17 years have received one dose of Pfizer vaccine, representing 8% of that target population. Of this, 12,282 are fully vaccinated. Hence, the cumulative number of people vaccinated with the first dose of COVID-19 vaccine for both adults and children is 500,220, of which 429,922 are fully vaccinated, translating into 24.1% of the total target population. It's important to note that we have reached half a million of people who have received the first dose of COVID-19 vaccine. This should encourage us to continue to get vaccinated until we reach our goal. In terms of summary, the cumulative cases so far, including reinfection, stands at 169,268, with 164,846 recoveries, giving us a recovery rate of 97.4%. 3,715 persons have died of COVID-19, with 351 having died of COVID-related illnesses, giving us a total of death of 4,066. So far, we have tested 1,062,931 samples since the beginning of the pandemic. And currently, the number of people we are having in quarantine facilities stands at 118. This concludes today's update. I thank you for your kind attention.
Thank you so much, Honorable Minister, for that very insightful report. Now, Namibia, as earlier alluded to, today we are talking basic conditions of employment in Namibia, and joining me in the studio from the Ministry of Labor, Industrial Relations and Employment Creation is Mr. Sho Henok Amkwa, my apologies, Deputy Director in the Division of Labor Inspectorate, sorry. Good afternoon, sir, and welcome to today's discussion.
Good afternoon, Elaine. How are you?
Thank you. Fine, thank you. Also joining us from the same ministry is Mrs. Emily Hamupolo. She is a Senior Labor Inspector in the ministry. Good afternoon, ma'am, and welcome to today's discussion. All right. All right. Now, the Labor Act 2007, number 11, is one complex, if I may put it, and jam-packed act that is filled with so much information. Mr. Amkwa, what is the basic conditions of employment in terms of the Chapter 3 of the Labor Act number 11 of 2007, and why is it important for employees and employers to know about this very act?
Thank you very much, Helene. Thank you, viewers. When we talk about the Chapter 3 of the Labor Act, it's about the basic conditions of employment. And this section clearly stipulate or outline the minimum terms and condition of employment. And that form automatically the terms and condition of employment in the contract of employment. And these terms of employment, it's that they are obliged or require the employers to actually ideal or just to comply. It requires the employer to literally comply or to do what this section requires.
Right.
So this minimum contract of employment is just set the basic conditions of employment. It does not require or does not give a permission for any negotiation for the party to negotiate about it, but rather to just to comply with the requirement. So this, it also where it gives the deviation from the employer and the employee, it's only when the employer can give more beneficiary benefit or condition to this section, but it does not allow the employer or the parties to negotiate below what is required in terms of this section.
Okay.
Yeah, so that's basically what probably I should also highlight or talk about the contract of agreement.
Okay.
So contract of agreement simply means it's just the agreement between the parties, which are the employer and the employee, the legal that meet the legal capacity, that have the legal capacity to enter into agreement. On one party, which is the employee, agree to render the personal services toward the employee, and also the employer agree to pay the ascertainable wage or remuneration. It is very important for employer and employee to know about this basic condition of employment, simply because so that we can promote the voluntary compliance and also for the employer. So as I have alluded earlier, that it does not need any compromise, we cannot negotiate about it, so it just obliges us to comply with this provision. And for the employees, it's also necessary for the employee to know they are entitled, what their entitlement is, and so that they can ensure that their rights or is per that condition, it's upheld.
Okay.
And in actual fact, this is just to protect this basic condition is to protect the employees from any possible exploitation, and which would not be neither for them, for their interest, not even for the public interest. Thank you.
All right. That is fair enough. I will stick with you, Mr. Amkwa. Could you kindly and briefly explain what Section 11 of the Labor Act on remuneration is? What is it about?
Thank you very much. Section 11 of the Labor Act, number 11 of 2007, it talks about the remuneration. It's a must. It's a statutory section that requires, or that it's a must that the employer should pay the remuneration to the employee who is entitled to get the remuneration, and it's actually say that payment, that remuneration should be paid either daily or weekly or fortnight or monthly. So it can be either paid in cash or deposited into the employee's account, and it should also be accompanied by the statement, which is actually in simple terms a pay slip, and which is clearly indicate the basic wage and the whole remuneration. Okay. And it's also important to note that this, whenever the employer is paying this remuneration, it cannot be done in other places where there's intoxicated like liquor in the bottle store or somewhere, unless such an employee is working at that place. So that's actually basically what the section number 11 talk about.
Okay. Mr. Amkwa, we still stay with you. You know, you've spoken about the wages and stuff. Is there a minimum wage for all jobs? And what are the different types of employment contracts that exist within the parameters of the Republic of Namibia?
Yeah, thank you very much. I can say that there is currently we don't have the national minimum wage for all the jobs in Namibia. However, it's very important to alert that at some sectors or industry, there are collective agreement that set the minimum wage and the conditions of employment. These sectors or industries are like construction. We have a collective agreement or in construction industry, and also in the security industry. We have a collective agreement that clearly stipulated or set out the minimum and condition of employment, and also in agriculture. So we do have that one, and we also have the wage order in domestic industry.
All right.
So, however, I would mention that Namibia it's busy on working out the national minimum wage. So hopeful after all the proper consultation with all the stakeholders, probably it will yield the good result. Thank you very much.
All right. Now, Ms. Samupolo, we have not forgotten about you. The Section 29 on period of employment, what does that mean? What do we mean by that? Or what does that section entails?
Okay, thank you very much. Well, as contemplated in the Labor Act, Section 29, which is a period of employment, only is talking about that is the time the employee worked for the employer, the period of any leave granted in terms of the above mentioned act, any leave of absence granted in terms of this act or granted by the employer for any other reason, any period of suspension when an employee is on suspension, regardless of the period they are on suspension, they are still regarded to be in the period of employment.
Okay.
If the employee has been reinstated, the period from the date of dismissal to the date of reinstatement. Lastly, it is the period of any lawful strike or lockout.
All right. Mr. Amkwa, back to you. Is it lawful to force an employee to sign a contract of employment that they do not understand? Because sometimes, especially in the informal sector, you would find that somebody is really desperate to find a job, and then finally the time has come, they are presented with a contract, and because they are pressed with time, whether perhaps due to language barrier, you would know that they are then forced to enter into that contract without even acquainting themselves with what the contract entails. Is it lawful to do so, number one? And two, who is then to be held liable if this contract is signed, should anything that is against the law be practiced there? And what consequences to be subjected to the guilty party here?
Yes, thank you very much. It's a straightforward that it's unlawful for one to force somebody to sign a contract that he or she does not understand. And for promoting the peace and maintain harmonious labor relationship at workplace, it is very advisable for every employer to at least give the ample time for the employees to go through the contract of employment with the aim of understanding of the terms and the conditions that are within that contract of employment. So, and also it will help the employee also to seek for any clarity or for any technical terms that are within that term of the contract of employment. Now, at the time where the employer forces the employee to sign the contract, so obvious, even force is a word when we are using the force. Force is a crime by
Yes,
itself.
indeed.
Yeah. In fact, that contract of employment should not be forced. Supposed not to be enforced for the first place, and it does not need even to be enforced. But however, if the employer exert pressure to the employee to sign such a contract, obvious the employee has the duty now to the burden of proof is raised to him to prove that yes, I was forced, and he must give evidence that will really going to take out any doubt that yes, there was a force, and if possible action can be taken, should all the evidence prove that yes, there was a force or pressure against this person to sign this contract.
Okay. You've briefly touched on that, it's obviously illegal to force someone. to sign a document. Now, in an event whereby this person is signed, the employee is forced to sign this contract, what then can, they are halfway through the process already, or the person is already employed, and then they just find out that they were actually, forced to sign that they weren't allowed ample time to acquaint themselves with the contract. What can then be done what can the labor law do to the employer so that they can, I don't know whether to retract the contract or perhaps to move ahead in an amicable manner?
Yeah, thank you very much. To check the contract, within that contract there should be terms and conditions, and those terms and conditions should be in line with Chapter 3 of the Labor Act.
Okay.
And if there is anything that contrary to that chapter, then it's obvious the contract is unenforceable, and it's an illegal, and should that contract comes to the Minister of Labor, obviously we will pronounce ourselves and advise accordingly whether it meets the basic condition of employment or not.
All right. Now, Namibia, as you know, this is a conversation of national concern. We are inviting our viewers and listeners to take part in our discussion today. And you can do so on our social media platforms. On Facebook, we are at Ministry of Information, Communications and Technology, Republic of Namibia. Or you can also stream us live on YouTube at MICT Namibia. That is our handle on YouTube. Alternatively, you can call us in studio. The call-in number is 061 400 397. The call-in number is 061 400 397. Mr. Amkwa, as we wait for the public viewers, the viewers' concerns and issues to come through, we stick with you. Please advise what an employee should do when they have exhausted all the means of internal procedures and believes that their plea is not answered in an effective it's not answered or effectively implemented in an amicable manner. What should be done then?
Yeah, thank you very much. If you have clearly said that the internal procedures, they are exhausted. So in the Labor Act, it's always advising or requires fairness in terms of substantive fairness and procedural fairness to prevail at each and every workplace. So to that case, I think it was, as you have alluded, that all the internal procedures, they were all followed. What's the last part of it's just about the appeal. So meaning that maybe the complaint
the complainant
probably is not happy with the outcome of the disciplinary proceedings,
yes,
because maybe the disciplinary proceeding give the disciplinary action, and then he appeal against the disciplinary action, and from there he is not happy with the outcome.
Yeah.
So obvious, if he is not happy, and that's a dispute, and he can refer the case to the Office of the Labor Commission for the alternative and dispute and the resolution process to take place.
All right. Ms. Samopolo, we are back to you. What are the deductions permitted from employees' remuneration in terms of Section 12 of the Labor Act number 11 of 2007? Okay.
Okay, the deductions and other concerning the remuneration. An employer must not make any deduction from an employee's remuneration unless the deduction is required or permitted in terms of a court order or any law, or subject to subsection 2, the deduction is required or permitted under any collective agreement in terms of any arbitration award, an agreement or agreed in writing, and concerns payment contemplated in subsection 3. The deductions made in subsection 1b must not be in aggregate exceed 1/3 of the employee's remuneration. A deduction referred to in subsection 1 may be made only in respect of the payment, the payment that the employee has agreed on, and that will be, and in writing, and that will be rent in respect of accommodation supplied by the employer, goods sold to the employer, a loan advanced by the employer, contribution employee benefit funds, subscription or levies to a registered trade union.
All right. Now, Act number 11, 2007 also speaks about the repayment of funds. What then happens if, for example, an employee has obtained a loan from the employer and has failed to do so? What then happens in that regard? Ms. Amopolo, you can take it, or Ms. Namkwa, you can assist her.
Exactly. When there are in that section also, what the one which was alluded to, it's also clear that the employee can, in writing, give a concept or in agreement that okay, this amount should be deducted from my account. That includes also the loan that were given in advance from the employer.
Okay.
However, it's that the total amount to be deducted it should not be more than 1/3 of the total deduction.
Okay.
Yes.
All right. And can that then be done at once? You've just earlier alluded to that it should not be more than 1/3 of the. Is it 1/3 of the salary of what the employee
Total
owes?
remuneration.
Okay.
So, for example, if your total elimination it's 1,000, then you divide the 1,000 by 3, and the answer now it's the total deduction. And if it's more than that, probably you can make an arrangement for installment until the loan is being covered.
All right.
Thank you.
Now, Namibia, as earlier alluded to, it is a conversation of national concern. We are inviting you to take part in this conversation and make your sentiments, your views, and contributions heard. On Facebook, you can join us. We are at Ministry of Information and Communications Technology, Republic of Namibia, or you can also reach us on MICT Namibia on YouTube. That is our handle, MICT Namibia on YouTube. Alternatively, you can call us in the studio. The call-in number is 061-400-397. The call-in number is 061-400-397. Again, as we wait for the viewers' contributions, we continue. Ms. Samopolo, please talk to us about what night work is. What exactly is night work?
Okay, night work is contemplated in Section 19 of the Labor Act. Night work will be deemed as a period of work between 200 hours and 7 o'clock in the morning. An employee is entitled to an additional 6% of the employee's basic wage, basic hourly wage. Also, in the Labor Act also make provision in Section 19 that no employer may permit an employee who they know or ought to know that the employee is pregnant to perform night work, including overtime, between the hours mentioned, that is 200 hours and 7 o'clock in the morning. The period which the employer may not allow the employee to work if they are deemed of if they are pregnant, that will be 8 weeks before their expected date of confinement, or 8 weeks after after her confinement. That's when the employer should not allow a pregnant woman to work. 8 weeks will be equivalent to
2 months.
2 months, yeah. So if the employer realized or was informed by the employee that she is pregnant, then they must make sure that 2 months before they give birth and 2 months after the delivery, they are not supposed to work in terms of the Labor Act.
All right, thank you so much for that information. But I'm asking this question on behalf of Namibians who find themselves in the fragment that, they are pregnant women that are perhaps health workers or other essential workers, and they find themselves working night work. What then needs to happen so that they are given the entitlement that they deserve?
Then if they have to do that, then they have to, an application have to be made to the minister for authorization. But then if that has to happen, then it will be what is that, Minister Amoko?
Okay.
It will be, so.
Yes, Mr. Anko,
Yes.
Would you like to add or contribute to her?
Yeah, I actually would like to end that obvious where the employees, it's up to the employees. They need to probably we need to give education awareness to the employees so that they understand this right, that the employees that the person or the woman who's find herself in the condition as she alluded is not allowed or is not allowed by the section to work.
Okay.
And the employer also should not permit a person to work while he's under she's pregnant, and if so, then the complaint can come to the Minister of Labor to lodge the complaint, and then we can take it from there.
All right. I have a follow-up question for you, Mr. Amkwa,
Yes.
but we have a caller on the line. Teresia from Otapi, good afternoon. Good afternoon, Teresia. Can you hear us? Teresia, good afternoon. Okay. Okay, we are experiencing a technical glitch there. I'm hoping that Teresia would call us back. We would love to hear from her. Mr. Amkwa, as earlier alluded to, I have a follow-up question for you. So in an event that, I'm an essential worker, for example, I'm a nurse, and 2 months in my pregnancy, I feel that I'm very fit as a young horse, and I can do the night work as much as I can, because I also believe that, night work has more compensation as opposed to that of day work. And I make it known to my employer that I would like to do night work. Then what then happens, or what needs to happen?
Yes, thank you very much, Elaine. As from the beginning, I clearly alluded that this basic condition of employment, they are obligatory. Yeah, they are stated that one need to require. We cannot be able to negotiate on that, and the employer, we cannot risk ourselves to take chances of that, and we just rather need to comply on that. No matter how healthy you are, and you that section requires you to not work, and the employer has also to ensure the compliance in terms of that section.
All right. Okay, we stick with you, Mr. Amkwa. What are the procedures of working overtime, and what is the rate or payment for work performed on Sunday or public holidays? Is there a calculation or standard calculation across the board?
Okay, thank you very much. The section 17 I believe it talks about the overtime. So it also it also says that the employer must not require employee to work overtime unless there is an agreement.
Okay.
Unless there is an agreement, and then that agreement should also, it's stipulated that in a day, in a single day, the employee cannot work more than 3 hours.
Okay.
And in a week, an employee cannot work over 10 hours in a week. And other than that, it's unauthorized overtime. Okay. And if the employers feels, or the nature of the work demand that he wants to work more than that, obvious the procedure is this. He has to write to get to be granted a permission from the Ministry of Labor, provided that there is a consent or agreement with the affected employee, and upon the submission of the submission for granted, should also attach the list of all the people who are affected, all the employees who are affected, and with their signature in agreement to that working overtime.
All right.
So the calculations is that obviously there are standard calculations, and it's all across. And for a person who works on Sunday, in terms of and public holiday, in terms of Section 21 and 22 respectively, obviously they have to be paid double.
All right. Okay, thank you for that information, Mr. Nkwa. We have a caller on the line, Henry from Windhoek. Good afternoon, Henry.
Good afternoon, ma'am.
How are you this afternoon?
Good, I'm good.
I'm good, thank you. What are your contributions, or how would you like to contribute to today's topic of discussion?
I actually have two questions. I believe the topic of your day is being chosen because of this thing going on social media about the councillor who went to parliament about the employees or the interns at the city of Windhoek.
Henry, are you asking us that question, or is it a statement you are making?
Yes, okay, it's a statement I'm making.
Okay.
Yeah, but what I wanted to say is, I have two questions.
All right.
One is about, I'm a unionist, and normally I speak for the workers, my colleagues.
Okay.
So my question I'm having here is about one lady. She contacted me from Oshakati, and she's working for Oshakati Town Council. She is a plumber by trade. Now I want to sketch the scenario here because I didn't know at that time. I only told her she must now remain where she is because at the currently she's having an employment. It can be that they will try to work her out and later on have a disciplinary and she's losing her job. So I told her she must just stay put where she is. She was seeing as a plumber by trade. Now she developed a skin condition. I don't know whether it's because of the sun or it's because of something else.
Okay.
And then the skin condition got away. But when she got the skin condition, the doctor now wrote a letter and said she cannot work in the sun. Okay. After that, as she was presenting the letter to them, they took her out of the sun. They put her in the office at the reception because there was nobody that time. Now, in the meantime, they were filling the position at the reception, and they no longer required her to be there. Now, she had now to go back to the plumbing station, but she couldn't work in the sun, so they didn't know what to do. But in the meantime, she went back to the doctor, and now the doctor said she's been healed by this disease or this skin problem. You are now free to work in the sun as long as you use the suntan lotion or that lotion to keep you from burning in the sun. After that, now she went back to them and asked them whether she can get the position back at the plumbing. But what they did was when she was there at the reception, they advertised the position and they filled the position at plumbing. It doesn't mean now she resigned. She never resigned. She was just temporarily moved because of the position she was in. Now they moved her from the reception, even from plumbing, to a cleaner. Wow. Demoting her totally. Now, can you tell me now, is that lawful? The experts now there, can you tell me?
Okay. Henry, your first question is you said you had two questions to ask. That is the first one. I just would like to, maybe you should say your second if there is a second question that you need.
Yeah, the second one is just about the condition now, I just say the current situation that the city of Windhoek. Are they allowed to keep on renewing the contract of the interns after every 6 months, remaining here for a couple of years? Nobody is coming in because of that. The students are finishing at the vocational center. They cannot come in because there are already other things that are now family members of this, that, and the other. They remain for a long time. I wish this is lawful.
All right. Let me just ensure that I've got your points correct, Henry. So the first question you've asked is clearly that of an employee of a Shakati Town Council.
Yeah.
And you said that she was hired as a plumber.
Yeah.
And then because of health-related issues, she was then certified by doctor that she's unable to work under the sun, and therefore she was switched to another department within the Oshakati Town Council. Is that correct?
Yeah, yeah.
And now you would like to know, because eventually they removed her from her position, and she is now reduced to the cleaner. That's what you are saying.
Yes, yes.
Okay, so the question you would like...
Is it lawful?
Sorry, Henry?
Is it lawful? Is it now, can they do that?
Okay. I'll pose your question to the colleagues in the studio. I'll pose it to Mr. Amkwa, and maybe he can assist us in that regard. But Mr. Mpolo, you can help him too.
Yeah.
Henry, also the one of City of Windhoek, you have alluded to that there is a scenario whereby the interns contracts keeps being renewed after 6 months, and they've remained there for several years. Is that lawful, are you asking?
Yes, I'm asking, can they do that?
Okay. All right. I'll pose your questions to the experts here in the studio. I'm sure they'll do justice to your question.
I'm listening to the radio.
All right. Thank you, Henry.
All right. Right.
Okay, Mr. Amkwa, maybe we can start with you.
Yeah.
What are your views on the callers?
Yeah, for the two, I have clearly listened to the caller's query.
Yes.
Those two questions. Number one, let me start with the issue of, it talks about the City of Windhoek. What I can say in short is that the attention is with the Ministry of Labor. That case is on the attention of the Ministry of Labor.
Okay.
So I cannot say further on that.
All right.
Okay, the other issue of the issue of Oshakati
Yes.
and the lady. And here I actually don't know whether the person is a representative of the, it's a representative of that lady, or
He said he's a unionist. And
it's a unionist.
Yes.
Thank you very much. If he's a unionist, I think it's very injustice for us to speak a specific case on air. Okay. And I just advise the caller for fairness to prevail, and also for the auditeram patema principle of hearing from both sides, to approach the Ministry of Labor in Oshakati, and then the case will be taken up from there.
All right.
Thank you very much.
All right. That is fair enough, Mr. Amkwa. So, Henry, if you are listening, clearly Mr. Amkwa has pronounced himself that they are unable to speak on matters that are, still in due progress. So you can contact the Ministry of Labor for the person that is based in Oshakati. They can contact the ministry's branch that side, and the matter will be taken up from the other side. And also the City of Windhoek's situation, the case has been registered with the Ministry of Labor, and again, he's unable to pronounce himself or speak on a case that is in due progress. All right, we have a comment on our social media platforms. Smiley Katambo says, does the law make provision to labor inspectors to visit companies to validate if companies do comply with the basic conditions of employment? That is straightforward.
Yes.
Any one of you can take it, Mr. Amkwa. You take the first lead. Oh.
Yeah. Now, as contemplated in section 125,
Okay.
it is very clear labor inspectors can approach a company at any given time and peruse or to see if organizations are complying with conditions of employment, and if not, if there is a provision that is not complied with, the necessary step will be taken. For example, a compliance order will be issued, or the employees will be,
Okay. All right. Okay. Thank you, Ms. Samopolo. That is well noted. We have a caller on the line from Oshakati. Good afternoon.
Yes, how are you doing?
Fine, thanks. Good afternoon, sir. How are you doing this afternoon?
We are very, very fine. How's that side?
Fine, thank you. How would you like to contribute to today's topic of discussion?
My question is just where can I find the article book for the law?
I beg your pardon, which article are you looking for?
I just want to so maybe I can rent and get a book so I can go through all the law of labor act. If there's anywhere we can find a book or they don't make so.
All right, thank you, Mr. Onesimus. I'll pose your questions to the colleagues in the studio. I'll actually throw this to Ms. Mupolo so she can assist us. Okay, he'll be listening on radio. All right.
No, I'm sure that he's talking the law book that he's talking about. I'm sure he's talking about the Labor Act, Act number 11 of 2007. It can be found even on Google. He just goes there and Google it, and then or he can approach any Ministry of Labor. Can be provided with the Labor Act in order for him to acquaint himself with the provisions of the Labor Act and the conditions of the basic conditions of employment.
Yes. Okay.
Yes.
All right. Fair enough. We have another call on the line. Okay. All right. All right. We are slowly but surely coming to the end of our discussion. But I'd like to find out from you, Ms. Mupolo. Could you please explain to us what a severance pay is and who's eligible to a severance pay?
Okay, thank you very much. Severance pay is an amount which is equivalent to 1 week per each year completed, and that is if an employee has been in an employment service for a continuous period of more than 12 months, then they qualify to be paid the severance pay. That is if they are dismissed, if they die while they are on duty, and also if they resign or retire upon reaching the age of 65. It is only not paid when an employee is dismissed via a misconduct or when with regards to poor performance, or also if the employee unreasonably does not want to be reinstated. And the calculation, like I said earlier, it is 1 week per each year, and that year must be full 12 months that is completed. Then once they are dismissed or once all the requirements made there, then they will be paid out the severance pay.
All right. Okay, that is duly noted. We have another comment on our social media platform. Zauda Neighbor says, it was clarified that deductions of an employee's pay may not exceed 1/3 of the salary for GRN workers, which is government workers. Some financial institutions exceed it. Can you kindly address this? What can you say about the sentiments of Ms. Nibas?
Thank you very much. So if somebody contravenes the law, does not mean that we should all follow the steps to do so. This is the requirement of the law, and obvious, I'm just encouraging the institutions to comply to what the law says. So that's in short what that I can advise.
All right.
Thank you.
We have another comment on our social media, our Facebook page. Ms. Hiriwa Kambo says, how are the security guards that earn a basic salary remunerated for work done on a Sunday or public holiday? Mr. Ankwa, maybe you want to assist us, or Mr. Mupolo, you can tap in.
Yes, thank you. Thank you very much. We have the basic conditions of the collective agreement on security. And it clearly stated that work done on Sunday, it should just be remunerated as such, to including also the security guard. So if it's double, should just be paid double for the work done on Sunday or public holiday.
Right.
Thank you.
Okay. Ms. Hamupolo, when does, in many cases, we hear of a maternity leave, and I know this is actually, a woman is entitled to such if she falls pregnant whilst she's employed elsewhere. When does a female employee qualify for a paid maternity leave? This is a paid maternity leave highlighted.
Okay, paid maternity leave.
Yes.
This will be contemplated in Section 26 of the Labour Act. It is when a female has completed 6 months of continuous service in the employment. If less than that, it will not be remunerated, and it will be an unpaid maternity leave.
Let me just see that I understand your statement clearly. Are you saying that if an employee is 6 months in her job and then she falls pregnant, she is not eligible to a paid maternity leave, or are you saying that she is?
When you have completed the 6 month period continuous,
Okay.
6 month period, and then going up, you
Okay.
will be remunerated. But anything less than that, it will be under unpaid leave.
All right. Okay. All right. Thank you, Ms. Amupolo, for that information. We have Ndeshi on the line from Oshakati. Good afternoon, Ndeshi. How are you this afternoon?
I'm good, thank you. How are you?
I'm very well, thanks. Thank you. Can you quickly make your contributions brief, please?
All right. I wanted to find out, let me say I'm restrained, and then at first I was maybe getting 500, and then the salary increased to 600, and then due to COVID, it was reduced to 550. So now when they have to calculate the final package, which one are they using?
Okay, Ndeshi, I would like to just ensure and confirm that I have your concern clearly. Are you saying that you were employed before COVID and your pay was 600, and then due to COVID-19's implications, it was reduced to 550?
Correct?
And so now you are laid off.
Yes.
So which package should they make use of? Is that what you're saying, asking?
Yes.
Okay. Mr. Amko, maybe you can...
Yeah, maybe I can ask Ndeshi.
Okay.
For how long the salary is being reduced? For how long?
Since last year, June.
Up to now?
Yes.
So you mean your salary, it's now up, it's now 500?
Yes.
That's your last salary?
Yes.
Sure. First of all, I really don't know the nature of how it's reduced, because to see the time it's very long. Or for one salary to be reduced for that period. Yeah, but as you said, you are in Oshakati. Yeah, you can just take your case to Oshakati Labor Office so that they will understand your case better. Because yes, because as you are saying about the time your salary has been reduced, I don't know what has happened there. How did you approach your employer? What your employer says? So you should at least, just take your case. Yes, just take your case to your office nearby, to your office there, Oshakati Ministry of Labor. It's your office there, though, so they will going to attend to your query.
All right.
Thank you.
Thank you so much. Bye.
Bye.
All right, Ndeshi. Okay, we have another social media comment. It's the last comment on our social media platform. It's on Facebook. I'd like to know, Ndeshi, it's Tresia Nuyoma. She says she would like to know if there are some employers who are exempted from paying severance to their employees. This is happening in a private company or private companies. Maybe, Mr. Amko, you can quickly share your sentiments on that, and in addition to that, please, your concluding remarks.
Exactly. Yeah. To that comment, the basic condition of employment, Chapter 3, the exemption and variation that can be done by the minister, it don't affect section 35, which is about the severance pay. Other basic condition of employment can be exempted. The minister can grant exemption or make some variation, but not to section 35 or 38 when it comes to the dispute. So to say there are companies that are exempted, my answer is that there's no company which is exempted from paying the severance pay, provided that you qualify for the severance pay as per section 35 of the Labor Act. So my conclusion remark is that I encourage all Namibians to acquaint themselves with the Labor Act, particularly the chapter 3, the basic condition of employment, so that they can be able so that we can be, as a nation, we can be able to educate each other and also to know our rights, and also for the employer to ensure that they are in compliance with the provisions of the Labor Act. Thank you very much.
All right. Ms. Amupola, any concluding remarks from your side?
Oh, okay, thank you very much. I will also just add on what Mr. Amukwa said, that the Office of Ministry of Labor is open 8 to 5, and everybody is welcome to approach the labor inspectors and seek clarity and more information with regards to the Labor Act.
All right.
Thank you very
Well, there you have it, Namibia. That is all the time we had for today's discussion. I sure hope that you've learned a thing or two from today's topic of discussion. Join us again tomorrow at the same place, same time here at the Government Information Center as we unpack another topical issue of national concern. From me, myself, Heleni Philippo Samunyela, and the entire GIC production crew, it's goodbye for now.